Welcome back to Atlanta and Company on this Friday morning. I'm Christine Pilara. The divorce, bankruptcy, and injury attorneys at Hait, Eichelzer Kuhn are champions for their clients. In partnership with Atlanta and Company, they want to help answer your burning questions. Right now, text HELAW to 25543 for questions, or you can even speak to an attorney. And this morning, Elizabeth Kuhn joins us one more time to answer some of your great questions, including one about child support payments. And welcome back. It's always great to have you.
Good morning, Chris. It's great to be here as always.
And I love our viewers. They're getting engaged with these segments now, and questions are coming out of the woodworks. Our first one comes from Stacy in McDonough. She says, my ex-husband is way behind in his child support payments. Is there a point where his visitation with our children can be affected if he falls further behind?
That's an excellent question, and a lot of times viewers do think that, oh, if somebody's violating the decree, I can also violate it. Very bad form, Christine. Just because your ex-husband, ex-boyfriend isn't paying child support, that isn't grounds to block the parenting time. You also are under a court order to comply, and people who aren't receiving child support, you need to be cautious that the judges get a little frustrated if you show up and say, oh, you know what, my husband or ex-boyfriend is $50,000 in arrears. The judges get really? You waited that long?
Right.
What took so long?
How did you let it get to this point?
Correct. And interference with visitation and punishing the children just because the other parent isn't doing what they're supposed to do really isn't the best way to do it. So you need to comply with the court order. You need to file a contempt action and go get your child support. You need the money, especially in the holidays.
Yeah, no kidding. All right, next question is from Ashley in Atlanta. She said, I stopped paying the HOA fees on my house when the short sale process started. Then 7 months later, the sale fell through. Now, the HOA has filed a lien and sent the outstanding fees to a debt collection attorney. If I am short selling a house, do I need to continue paying the HOA fees?
That is an incredible question, and that comes up often in the area of bankruptcy or foreclosure, short sale, things of that nature. Unfortunately, until the bank takes title of the house or the new purchaser, if you're short selling, you are fully responsible for those HOA fees. You can't even discharge them in bankruptcy. And homeowner beware, they're going to send it to an attorney. The attorney knows they're going to win, so maybe you're $3,000 behind. Before you know it, you're in the middle of a lawsuit and you're hit with an additional $3,500 to $4,000 in attorney's fees.
Oh my goodness.
So your $3,000 all of a sudden jumped up to $6,000, $7,000 when you're already financially struggling and there's nothing you can do. Homeowners beware, keep up with those HOA fees, do the best you can, call them, try and negotiate some type of payment plan before it goes to the lawyers.
Do not put that one on the back burner for sure.
Absolutely not. And it's such a huge shock and a huge surprise, and we see it every day with our clients who are suffering with the thought of even losing their house. And what's even more important is you get these clients that come in and they say, you know what, I'm going to surrender my house in bankruptcy. And so they move out. The bank doesn't foreclose on the house for a year or two, the homeowner owes the HOA fees.
Wow.
So homeowners, beware.
Okay, great questions again. Now, Tamara from Roswell writes, if I consulted with a lawyer and chose not to retain him, can my husband retain a lawyer from the same firm?
That is a complicated question, and the answer you're going to get is it depends, which often our clients don't like to hear, but that's the reality of the situation. For example, in our office, when somebody comes in, they might just be asking something simple. How much does it cost for an uncontested divorce, no kids, no assets? $500, $1,500. How much does it cost? There's no legal advice distributed. It's just a very matter of fact, here's the price for the services. A year later, perhaps the spouse comes in and says, you know, my soon-to-be ex-husband hit me last night, there's a TPO, police are involved, all of a sudden there's an exchange and a dispense of legal advice. That's where the line is drawn. Okay. So in our office, we explain that clearly in the retaining appointment that whether or not they're going to receive any type of legal advice. And really, the attorney needs to be responsible and take copious notes. And our firm does that. So it's very important. And I apologize, but the answer is it depends.
It depends. All right, the next question and last question is from Cheryl in Snellville. This is a sad one. My mother has credit card debt she cannot pay. She's on Social Security and lives in a home that was left to me and my brother after our father passed. Well, the credit card companies are calling her and they're threatening her, even telling her it's going to be turned over to the county. She lives in Georgia. What can they actually do?
Again, this is another depends, and we would need a little bit more facts, and you can feel free to call the office. We can answer this in 5 minutes with a little bit more information. Basically, Georgia has homestead exemptions. That means that you can save $10,000 of equity in your house if you're single, $20,000 if you're married. In that type of situation, the bankruptcy court does what's called a look back. When your father passed away, did he purposely leave the house to the siblings because he knew creditors were coming? All sorts of things factor into that, and that goes into the whole estate plan. Now, the good news is the credit card companies, the worst thing they would do if they find out that the mother gifted the house, or I know she said the father left it, they can file a lien on the property, perhaps go back, but they can't garnish Social Security wages. So if there's a lawsuit, you can be rest assured they can garnish your bank account, even if you put your Social Security, but they can't actually garnish the wages.
Okay.
So really, unfortunately, again, another great question. You need to consult with an attorney.
Right.
We're available right now if you'd like to call in, and we can easily answer that question depending on the facts.
Okay, it's always so great having you here, and thank you, viewers, we appeal to you to please ask your legal questions, and you did, and we'll have more of those in the coming months. So
yes.
Thank you so much. And I always have boot envy, shoe envy when she comes on.
Great.
Excuse me, ladies,
Great.
Would you please check those out? Anyway, if you have a question or you'd like to speak to the attorneys at Hait, Eichelzer & Kuhn, please text HELAW to 25543, and someone from their office will get back to you. And for more information about Hait, Eichelzer & Kuhn, log on to their website, he-law.com, or give them a call at 770-517-0045. And this segment was paid for by Hait, Eichelzer & Kuhn, attorneys at law.